Welcome, everyone. Thanks for joining us. We've got a case to review tonight, but a couple of administrative items at the top. We'll do attendance, approval of meeting minutes. Mummy will be joining us virtually when she's done with the county board meeting engagement. So she'll join us shortly online. But I'll go ahead and just call attendance real quick. Did everyone have a chance to look at the meeting minutes? Any questions? Then I'll go back to attendance. We've got Commissioner Montgomery. It's not here yet. Commissioner McCullough is not mine yet. Commissioner Shotkin. Present. Commissioner Smith.
Up here.
Commissioner Dansby.
Present.
Commissioner Evans here. Commissioner Ortiz.
Here.
Wonderful. And Commissioner Montgomery. Wonderful. Okay. So we do have a quorum. We'll go ahead and get started. Any questions about the previous meeting minutes or comments? Nothing. Do I hear a motion to approve?
I will move that we approve the meeting minutes from the May meeting.
Wonderful. Second.
Second.
All in favor? Aye.
Aye.
Lisa, Anika, you're good on?
Oh, yes.
Yeah. Any abstentions? Great. We will adopt the meeting minutes.
Why are you in uniform?
I had a command staff meeting.
Oh.
Yeah,
Never
so
put you in
whenever there's a
uniform.
command staff meeting,
Okay.
I put it on you.
I guess I've seen you in it, so I didn't know the difference.
It's
but-
not often.
Yeah.
Okay, I think we wanted to revisit policy recommendations from the last meeting. Dave, do you want to?
Yes. Okay. So the first item here is a follow-up from the case that we discussed in May, which was a case involving a situation in the Clarendon bar area. After bars closed, there were some rowdy patrons outside, and an ACPD officer came to the scene, arrested someone who appeared to be intoxicated in public. But as part of that arrest, took the individual's phone and deleted a video of the phone, which was of the officer affecting the arrest. The individual who was arrested was drunk in public, but was on the scene filming on his phone. And so the result of OPR's review found that the officer violated the search and seizure policy and the personal tax policy. And the COB voted in similar fashion to find a violation of those same policies. But this that relates to the facts and wasn't something that was explicitly reviewed as part of the investigation. And that is that given the fact that the officer took the individual's phone on the scene and deleted a video of himself affecting the arrest on the scene, and that's an issue that impacts the public's First Amendment right, which is a significant fundamental right that everybody has. And we've discussed it with ACPD and let them know that we were going to make this recommendation, which is that given the fundamental nature of the right at issue, we thought it was important enough for ACPD to, I'll just read our recommendation, that we recommend that ACPD, quote, take steps to ensure that every ACPD officer is reminded of or educated the public's First Amendment right to record and photograph officers in the public discharge of their duties, as outlined in policy 574-02. So that's our recommendation. I'll just leave it at that for now. I mean, if any other comments anybody wants to make, please do.
Also, welcome, Charles. Thanks for joining us.
And for the record, did you say Commissioner Montgomery's here?
Yes.
Oh, you noted
I
that.
did.
Okay. Yeah.
Thank you. Any questions or discussions about the policy recommendation?
I do, just one thing. You mentioned, Albert, last time that your sense is that this is not a big problem with ACPD, and I agree with you that the police officers absolutely, everything I've observed, they're very respectful and you totally get the fact that you need to film it. So I kind of struggled with whether or not it made sense to take the recommendation, The reason I agree with it is because it's a personal. And I would think that any time there's a violation of constitutional rights, that's the reason. But I did want to tell you that I'm sure all of us, and certainly I'm aware of how good ACPD is. Didn't want you to think that I didn't want you are.
Well, first of all, Lisa, I really appreciate you recognizing that. And I would agree with you that, you know, the upholding of an individual's constitutional right is one of the fundamental tenets of being a good steward of law enforcement, a good police officer. So that you will get no disagreement with me. And I think if you remember the last time we had this meeting, it was just a management sort of concern I had. I have no problem, and I don't think the agency has a problem of reinforcing the core values of, you know, upholding rights, which we do on a consistent basis. We don't, you know, about all of our core values and all the sort of important things that make a good police officer a good police officer. Those are fundamentally brought forward every single time that we have training. The only concern I had was about the level of the voice, right? And so when we talk about how loud someone's voice needs to be, I need to make sure that the volume of my voice when something is delivered, because there is an issue, that is not muted by consistent things. I 100% agree with you that constitutional rights is up there. And if I thought that this was a pattern of behavior amongst police officer, I would be right there with you. That's my only reservation. Not that it's not important to reinforce, but I want to make sure that the voice that delivers messages can be as loud as possible, because there may be a time when we confront something where it's more than one case, or we are starting to see a pattern. Then that volume of that voice needs to be incredibly loud. And I think that over the course of the last 2 years, that I've been able to sort of temper what needs to be delivered, what is an isolated incident and not systemic to the agency. And I thank you for recognizing that. And so that was the only concern. But, you know, I'll let you guys have your vote. That's just it. And like I said, I just do want to reinforce, and thank you for reminding me, that this is not a systemic issue. This is an anomaly. It's a one-off. I've been in the office for 3.5 years. Here is my, you know, my predecessor who was in the office for many years before me. This is an anomaly. It just does not happen. And that's why.
Yeah.
And that it's like an anomaly. And so
Yeah.
that's it.
I think something that was really valuable that came out of that discussion was the kind of insight into the sort of domain-specific training you guys have put together for like the Clarendon and Crystal City. I can't remember if we got access to the
We did.
materials. We did.
Yeah.
Okay. Sorry, I'm
Mhm.
behind on emails, but I think our ability to sort of, just like the initial training, right? We sat and waded through a lot of, you know, how the department is organized, what the different functions, roles and responsibilities are, but seeing those things one time doesn't always like soak in for us the way, you know, working in that space every day does. So that's really helpful. We appreciate you sharing it. I mean, anything?
On that note, I
Yeah.
just wanted to what you're saying in terms of training, because we've redone our training section in itself, and it's really robust, especially compared to most jurisdictions in itself. Those topics are hit. We are pre-academy going through those constitutional values to break it down to ensure that people gather and understand it. Now, one thing is we can pound, give explanation, give scenarios, but it's always going to be the person's application at the same time. So I think the understanding is there, application in that situation is true.
Well, we appreciate the kind of insight and engagement. Do we need to vote on
But
that?
I don't know. I hadn't, we haven't actually,
No.
yeah, I don't think we actually have to. I think it just, I
Okay.
mean,
Okay. Mummy, anything you want to magnify or clarify?
No, I echo the recommendations and on my report. It's my hope that with us having additional capacity, like a deputy, that I will be able to like actually attend and assess these trainings in real time and just have a better appreciation for like what they look like. Because I think that as I mentioned in the last meetings, some of the information got here and that we're making recommendations sometimes based on what we like things to look like. And they may already be existing in the training, or there may be lapses in the training, but we won't know that without having that information.
Yeah. Okay, thank you. So the rest of our agenda, we've got an investigation to review. I've got some updates. I know Mommy has some updates. Do we want to, I know you're gonna switch to virtual partway through. Do you want us to open and then?
I can provide my updates real quick, and then maybe as you guys are opening, I'll switch over to virtual. I have to go get my daughter, and then
Okay.
for the rest of the
Sure.
if that's
Sure.
okay, I'll-
Yeah.
Yep.
So just really quickly, you all have met one of our interns that they started. They'll be here through the rest of the year. Hopefully you all have had a chance to meet him. Vikram is our other intern. They started a few weeks ago and will be here through the end of July. So just encourage you all to reach out if there are any things that you can that they can really assist with. But we are ramping up our community engagement in large part as a result of their pitching in. We tabled at the Blues Festival this past weekend as a community engagement endeavor. We are looking at trying to also table at the county fair in August. And then we are currently looking for spaces for next month's meeting in lieu of a COB meeting, having a community engagement event to commemorate our 5-year COB anniversary. Separately, the CNA traffic stop report is in the final stages of production. So we're hoping that will be released at some point in the near future. Again, apologize for my tardiness. As I mentioned to you all in the email, we're just working through some of the records access issues related to the officer involved shooting that happened in May. So it looks like we have a mechanism to address that in this particular incident so that I can begin just having a full appreciation for the underlying actions that took place. And then we are also going to meet separately to create a more defined protocol for any incident moving forward to make sure that I have contemporaneous access to interviews when they're happening, as well as body camera footage related situations. So more on that later, but I just wanted to provide y'all with an update that we at least have a resolution, I think, for this particular matter. And then it's clear that we could outline some additional things as it pertains to information sharing to use in other instances. Luckily, it's not something that happens very often, but we have been working through a lot of other issues, MOU ordinance, and we've had to take the time sometimes when an issue comes up to formulate a separate protocol to deal with those issues. So this is very much similar to that, but just due to the serious nature of these types of incidents and the need to be very intentional about preserving the criminal investigation or the integrity of the criminal investigation versus an administrative investigation, which is our purview. We wanted to make sure that we have a meeting of the minds of you all with all of the people who are stakeholders in that conversation and make sure we outline the protocol that makes sense for all of the needs.
Okay. Thanks for that update. Just for clarity, so the CNA report was the traffic stop analysis, and we'll have them come. We'll do we'll walk through that at a separate conversation. So we'll have more information to share on
I
that,
think they'll do presentations.
Yeah, like they did before.
To present their findings.
I know there was that community publicity, so then we should make sure that it's distributed fairly broadly so that
Yeah, people know that it's available. Yeah, sure. Great. Thank you for keeping tabs on that.
Just a quick question on the CERT reviews. I know we reviewed, see all of them or just the ones you think we should see?
You'll see all of them, but my access to the information is usually at the beginning, and then once the investigation is concluded, the administrative investigation, which really doesn't formally start until the criminal investigation. So it can be months to a year sometimes before we actually begin the administrative investigation officially. What I would like to do though in the interim is still be able to have access to, or the purpose of having access to interviews and related digital evidence is to just make sure that I have an appreciation for what else taking place. And outline any sort of administrative issues that may need to be addressed and when and how they should be addressed. But once the administrative investigation is concluded, similar to any other public complaint investigation and that sort of things, when you all would have access to all the records and we would review it at a COB meeting.
Thank you.
So should we move to the next item?
Yeah, I think we'll go ahead and dive in. This is CMP 24, right? 24 CMP 060.
Right.
Sounds good. Thanks, Molly.
Thanks, Moe.
So this was Dave and Lisa were the co-investigation leads. Dave, we'll turn over to you and then we'll jump in when we go.
Okay, great. Lisa, if you want to
Yeah,
go through the,
so by the way, I wanted to ask, I probably should know the answer to this, but are these slides made publicly available?
They're in the meeting recording. I don't think they get updated uploaded separately to the website.
I'm just gonna suggest maybe we think about that, but I mentioned partially because I'm not gonna read exactly David's excellent PowerPoint. I'm gonna try and summarize it even more. But we should pull it up. We should go through it anyway. We should look through it, and then obviously when we get to the actual potential policy violations, and so Dave, stop me if I
yeah,
say
no, go
something
for it.
wrong. Okay. Okay, so the allegation is that an officer uttered a racial slur as he exited a courtroom after testifying, and the racial slurs there, please don't make a mistake. As he was walking down the aisle, past some individuals who were attending the trial, the sitting. The defendant for the case was African American, as were his close associates who were attending the trial and sitting at the gallery. The officer was not African. 4 individuals who were sitting in the gallery alleged they heard the racial slur. 3 of them were associates of the defendant, including two family members, they're close relation, and 1 was an individual from the public defender's office. They were not all sitting right next to each other. As my recollection is the public defender's office was sitting a little bit farther back.
So that was the defendant's mother and father and the father's girlfriend.
Right.
And they were sitting, the mother and the father were sitting right next to the aisle. And the girlfriend was sitting 1 seat over. And the 4th person, the defense counsel intern, was sitting also right next to the aisle, but on the other side of the aisle. And I think one row back. She was 1 row back.
Okay, additionally, there were 2 sheriff's deputies who were also in the courtroom, but they never went into the gallery. They were closer to the judge. And they both said they didn't hear the officer saying. So the 4 individuals discussed amongst themselves what they believed they heard, and they also spoke to the defense attorney, letting them know what they'd heard. A week later, the 4 individuals, witnesses, gave statements about what they alleged they heard. The officer was also interviewed. He admitted to saying something that included a 4-letter word. Do we have what he says?
Yeah.
If we get to, is it there?
It's the first
Yes,
bullet.
okay. But that this did not include a racial slur and that it was directed towards the defense attorney because he was upset about cross-examination and was not directed towards the defendant or the defendant's family. He also said that he muttered under his breath and that others may have heard him. That's the basic facts of the case. And then, essentially, there's a question of trying to determine, these are all trying to determine who is telling the truth or who isn't telling the truth. And of course, there's always an option that everybody's telling you, that the individuals who alleged they heard something believed that they heard what they heard, but that the officer didn't actually say what it is that they think that they heard. I do think it's worth mentioning that what the officer says he said, although my recollection is that he said, I think I said, or this is what I think I remember saying, or something like that. Doesn't sound anything like what the individuals say they heard, which You can either take that as the officer couldn't quite remember what he said, and he this is kind of what I said. Or, you know, take it as you will, but the two things certainly don't sound anything alike. So then there's two potential policy violations. Does anybody have questions from there? If anything wasn't clear, or Dave, did I miss anything critical?
The only thing I'd add is that during his interview, Officer 1 described his mental state and
Yes.
why he was frustrated. He said he was frustrated at the defense attorney's cross-examination, and that the defense attorney apparently, or someone associated with the defense attorney, had tweeted or posted a social media thing that said he was going to lie on the stand. And what was the third thing? That he was just
His attorney didn't.
Commonwealth attorney did it.
yeah, that he was, so he's frustrated with the whole thing.
So
There was context that it was not necessarily directed at the people he was closest to.
yeah, exactly.
Is the
So
takeaway.
what he was saying is, I did say something inappropriate, but it was about the defense attorney. It was not about the defendant, and it was not about the defendant's family.
It wasn't to anyone.
Yeah, it wasn't to anyone, and it wasn't even about
Right.
individual. Oh, and the defense attorney is not African American, so I think it's okay, so there's two potential policy violations that might fall under this, and the first one is conduct unbecoming. And I think the relevant language is highlighted there, which is conduct which has a tendency to adversely affect, lower, or destroy public respect and confidence in the department or any employee, thus bringing the department or any employee into disrepute. So that's really the crux of conduct unbecoming.
And just because this is a very serious policy allegation, like the most serious, I think it's worth just interjecting that this allegation was withdrawn, and that the IPA, and just for watching back the footage, that it was considered because of the seriousness of the allegation, but it was withdrawn. So really the focus is on personal contacts.
And then the second one was within personal contacts, and this one was not withdrawn. So the employee will treat all persons with respect and will not use degrading, profane, abusive, or defamatory language when in contact with the public or other employees or them. So those are the two policies. It's, as was stated, the original one was pulled back. This is one that was really considered. Do we want to move? Is the next slide is?
Yeah,
what we came down to? Do you want to take that?
Yeah, I'll take that one. So the reason that this is included is because in most cases, the facts are pretty clear. And the question is, do those facts warrant a violation of policy by the officer? But here, the facts could be in dispute. And I think that's one of the things that the first thing that the COB has to decide is, what are the facts? And so I put the standard up there, which is you need to believe that it's by a preponderance. So more likely than not, you can't just be like, well, it could have happened. It has to be at least 51%. And so I wanted to put that out there. I will also add that before we talk about the sort of how the facts apply to the policy, that OPR did a really strong investigation. I mean, they took it really seriously, and they ordered the audio tape of the hearing. Captain Kim went to the courtroom, as did Mummy. ACPD set up an audio test whereby they tried to record something and see if it would have been picked up with the recording device that they used. And so I just wanted to acknowledge that they took it really seriously and drilled down. They interviewed all the witnesses timely within a week, which doesn't always happen. And I think I know they interviewed, actually, I don't know if Mummy interviewed one of the people, but they interviewed the mother, the father, the intern, and I think Mummy interviewed the girlfriend, I think.
Everybody who was sitting there.
Yeah. And the two deputies, and they took additional steps to really drill down on it. So I just wanted to make sure that that was clear, that this is obviously something that they took really seriously, as they should. Because if the facts panned out that the officer one said that, it's a pretty serious thing. And so hence the effort put forward to try to figure this out, which I appreciate. So let's go to the next slide, because here there are different, I mean, there were 4 people that said, I heard the officer say black motherfuckers, which is an outrageous statement. And that's what they heard. So, and there's 4 of them, and they all said the same thing. So it's not without some weight at all. And just sort of going through how this might stack up. So if in fact COB were to find and vote on like what are the facts, I think those facts, if you were to believe them, would lead to a conduct unbecoming violation, because it is that serious. And conduct unbecoming between the 2 policies is much more serious. And this is something we've learned from ACPD. The level of discipline would be higher. Personal contacts is an important policy, but it doesn't rise typically to the level of something that's conduct unbecoming. So I'm going through the first bullet here on this slide. If you were to find, and we haven't discussed this as a whole body, which is why I'm sort of going through this. So if that's what you were to find, that might be the outcome, the policy outcome. If you were to find that the fact is that the officer said what the 4 witnesses testified that they, or recounted that they heard, he said. Or I think the other possibility would be that if he didn't use the racial slur, but intentionally lied under essentially, it's not really under oath when they talk to you, is it?
Yeah, well, it's just lying, but it's just as serious. If you lie to OPR,
right,
you're gonna get fired.
Right. So
There's no coming back from that.
right. So again, if for some reason it was thought that officer one remembered exactly what he said and intentionally dissembled or lied in front of OPR, that would be potentially another route to conduct unbecoming. Third thing is, okay, if you think that the officer said something that was foul-mouthed, but not the racial slur, and just literally couldn't recall exactly what he said during that incident and told OPR, this is kind of what I think it was, then that probably leads to a conduct unbecoming violation, which is what OPR found. So I'm sorry, yeah, personal context, right, thank you. So all of that said, I mean, and now we can sort of discuss it, because I mean, I come out on the third prong here. I mean, I really kind of thought through this. I don't think it's any disrespect to the 4 witnesses who all believe that they heard the officer say black motherfuckers. I mean, there's no evidence, but I think one other possibility would be that he said that motherfucker. And because to me, that seems more consistent with his level of frustration and who it was directed at, which is the defense counsel, I think. And it makes sense. He was very frustrated about the cross-examination, and that would be one possibility of something that he could say. The other thing is, we did, I think Mummy requested, and we did look at prior discipline associated with Officer One, and he's been on the force for 32 years, and there was no indication of prior racial allegations against him. And given the outrageous nature of the statement, I mean, and everybody can have a different view on this, but my sense is something like that probably would have come up before if he were someone who was not, you know, that maybe not. It could be something like that could happen as an initial matter, but my view is that if you're going to say something as outrageous as that, it would be not unlikely to me that you would have some at least allegation against you in your prior 32 years. That's just my sense of it. So given that there were no such allegations, and given my review of his video and his discussion with OPR, and for what that's worth, my sense of his credibility on that point, and given the facts of what he was, I believe, frustrated about. And the other thing I'll throw in there is that the 4 witnesses, in particular the father and the mother, said that they thought it was directed at the father. And Officer One said, look, I don't recall the father And I just thought that was kind of unlikely. The father lived in the area years ago and said maybe he thought that the officer had some specific beef with him. But again, I don't think it's any criticism of the four witnesses to say that they heard something like black motherfuckers, which could be that motherfucker. So having said all that, I just thought I'd lay out where I come out on that, but we should discuss it because which facts you believe happened make a difference on, I think, how the vote would go once we were ready to vote.
Yeah, I want to just interject briefly because I think there's another facet to the circumstances that we want to get into, but for the purposes of the vote on the policy, the alleged policy violation, we can stick to the 4 people reported that they heard something that would be not just wildly offensive, but a fireable offense. How that was explored and discussed in information in the interview, and then we can get into the broader context of the case for.
Right, there's another issue that we want to raise that wasn't part of the investigation.
But for the COB, are we kind of comfortable talking about the the alleged policy violation first, and then this, or do we need to cover that before we go into discussion? Otherwise, we'll let Mummy and Albert add their context.
Yep.
Well, adding that context though, if you would, for both Mummy, independent police auditor as well as OPR, could you briefly explain kind of the distinction or the decision that goes into withdrawing something rather than not sustaining it as well?
Yeah, so I think in this case, we know that he said something that he shouldn't have, because he self-admits that. He says like this profane language in view of the public, right? Or around the public. So we know that you're not supposed to do that. And when we make a decision about, and I'm going to get to this, but we know that that's not supposed to take place, and I can't just wipe that away. He's admitted to it. There's been an allegation that something was said in a courtroom while court is in session. We know that you can't do that. And I can't say, well, it's not sustained conduct unbecoming because it's such a serious charge. So I'm just gonna not sustain conduct unbecoming. Because what I've done then is I've moved the goalpost. I've moved the line of what's tolerable, meaning like, oh, well, if that's the case, then I guess you can say a 4-letter word while court is in session in view of the public, et cetera, as the judge is taking the bench. So in order for us to take a look at what happened, we had to find what was more appropriate. And in this case, personal contacts, as Dave kind of sort of brought up, is a lesser type of offense when you do something like that. So when we withdraw something, what we're saying is we're not gonna hit you with conduct unbecoming sustained and personal contact sustained conduct unbecoming not sustained, because how do I justify that? Because if you look at the words of conduct unbecoming, it kind of fits in there too, if you know what I mean. Let's say he does say, you gotta be fucking kidding, or that motherfucker. It kind of fits in conduct unbecoming, right? And so I'm not gonna sustain that and sustain personal contacts. Am I starting to make sense? Am I?
Sort of, because I think that the last bit of what you're trying to explain right now is the part I'm getting cut off on. Like, I don't understand why you couldn't not sustain conduct unbecoming, and then also sustain personal contacts, because what was alleged to be said may have been different than what you likely found.
Yeah, I think for us, it's cleaner when we do it this way.
Okay.
So it just is cleaner. And we have withdrawn different offenses that we feel are more appropriate based on the evidence that we've collected. But if I have a preference to not sustain something, I'm going to try to do that. It's just cleaner. Yes.
So, for example, I mean, you investigated the more serious allegation because that's where it would fit if certain fact patterns matched, but not reaching that, introducing a related thing that kind of is in the same domain.
Yes.
You're saying, and we've talked about this before, like there are instances where, sustaining multiple allegations that are related or based on the same behavior is warranted, and situations where it's not. And so in this instance, like if you were to sustain, I mean, in this example, it might not be that helpful, but if you sustained a conduct unbecoming, you could sustain a personal context, but that wouldn't really matter because CUBE conduct unbecoming would govern. But so because you introduced the second it's not like they were two separate policy violations based on two different sets of facts. It was,
Correct.
this one was introduced, it was explored. Because the conduct didn't seem to rise to that level, you introduced another one and then withdrew the other. Is that what you're?
Yeah, so let me, I'm trying to give a better example.
Sure.
They're interrelated. Okay.
I think we talk about in the criminal element of lesser included offense, like that offense, personal context is within conduct unbecoming. And as you said, if it's gonna reach that higher level, then you're gonna go with the conduct unbecoming. You're not gonna put both of those on the table. But as you also spoke to, and I think that's accurate as well, if conduct unbecoming is where you started and you realize it was not that serious, you don't wipe that away. That when things go into those systems, delete is not an option. You need to give reason why you got there. And this, to me, if you're looking at it, that's very clear what that actually is.
And a racial slur versus profanity are just very different.
I think you hit the nail on the head, which is, and again, I was kind of alluding to this cleaner, is like, if I slide over like an allegation of conduct unbecoming, I'm stuck with that. I have to do something with that. And to your point, Joshua, you're like, well, why don't you just not sustain it? Because they're interconnected too much. And they're a little bit too connected that I'm not going to not sustain one and then sustain the other. To me, that honestly does not make sense, because I would have a hard time justifying. I have to do something that I feel is more appropriate.
Would you feel it's inappropriate to exonerate?
No.
Because of the language is, because
Well,
the,
then there has to be evidence that, right, there
Yeah,
has to be
yeah.
evidence to
The
exonerate.
cleanest way to deal with this was the way that it was done, which is to
Yeah.
withdraw the more serious charge. Is like, kind of like in the criminal code, hey, we're null processing the murder charge and it's gonna
Yeah.
be X, Y, Z. It's essentially the same thing.
Yeah.
Kind of a null pros, and then this is what you actually did. It's sort of synonymous to that. You don't not guilty, right? You don't, or you say, it's indeterminate about murder, but you definitely did this involuntary manslaughter. Does that make sense? I'm using this as sort of an example. You would just null process it and then go with the lower one.
And the part is, it's already part of the record, because
Yeah,
you notice.
you're stuck with it.
You
It just
notice
is
that
there.
officer initially, and once they notice that slide in the piece of paper, reading and that's the allegation, that's part of the record. You can't delete that part of the record. It has to be in the part of what transpired to get you there.
So Joshua, you're saying when we don't have enough evidence to sustain something, we typically we make it not sustained because there was an allegation we can't exonerate.
Right, yeah,
And
no, I
so
mean, like, the
what-
definition of not sustained, right, is insufficient evidence to either prove or disprove the allegation. My concern is that withdrawing something sounds like you made a determination that, to your point, it was inappropriate. Which is to say that this fits better. And I get your lesser included offense and the analogies make sense. I've done criminal law as well, and so when it comes down to it, I think my problem is one, we're dealing, of course, with preponderance of the evidence, not beyond a reasonable doubt. But I think also to your point, if you do have a heinous crime, a murder or something like that, and you're like, I'm not sure we have enough for that, but we have involuntary manslaughter. You could do that, but that's saying that we don't have enough for murder, which would be equivalent here to not sustained. And then you're like, but we can't sustain the lower one. And I get that it's cleaner. If it's cleaner procedurally and everything else, then that satisfied me enough to know why it happened. I'm not sure the reasoning is something that I think totally makes sense. But I appreciate you kind of walking it through, because I wanted it for my edification, but I also just wanted anybody that's listening to also recognize that difference. Because I also feel like not only OPR, but we COB sometimes just don't use not sustained. And it's a little frustrating to me when we have 4 different categories and we don't use things when they have definitions. And so I think that clarity is good to know. I do think it is possible to have a situation, maybe like this one, maybe not, where what you say, or the allegation of what you say, because if it's heinous, it could be kind of, I mean, if it's not heinous, but it's still bad, It could be something lesser like a personal contact. So I think that's entirely possible. That may be exactly what we have here, what we may end up voting on. But I also don't see a reason why that couldn't be not sustained to say, we don't have enough to say that there wasn't conduct unbecoming. Because if we do actually think we do have enough to say that, then to everybody else's point, we have something else for that too. And so I think that, I'll rest there, but I appreciate the explanation. I think I understand it enough.
I think you raised a really important point. I'm sort of the view that it would actually be more appropriate to exonerate because if we're saying we believe that he said that motherfucker, then if that's as opposed to, this is really complex, as opposed to ultimately, I don't know what he said, which is kind of actually where I am. There's no evidence, there's no affirmative evidence that he said that motherfucker, like nobody said that. So actually it's hard to say, 51% think that. But I don't know what he said. But if I thought that he did say, if for whatever reason, I come to the conclusion that he said that motherfucker, then to me, unless you're going to say that language in and of itself justifies conduct unbecoming, maybe it's better to just say, well, it's exonerate. That we don't have, what is the definition of exonerate?
Definition of exonerate is incident occurred but was lawful and proper.
Like there's.
Oh, okay,
evidence to
okay,
confirm that
okay,
No
okay.
policy violation occurred. I'm
Okay,
gonna
all right,
pause.
no, so
Honey, did you want to weigh in?
Yeah, just to say, one, as a blanket rule, I do not support multiple allegations against an officer for the exact same conduct. I don't think that that is a fair practice or a transparent practice. I do believe that it's absolutely appropriate for one incident to result in multiple allegations, to address different conduct, but we're talking about the same statement. To have multiple allegations in one investigation is not something that, like, from a professional standpoint, I support, or that I've seen, other departments practice. I think what we do is we go into these investigations with what we think, just based on what the complaint articulates, is the allegation that is going to most appropriately fit the facts and circumstances. But then sometimes we learn things in the interview, and it can go both ways, by the way. Like, it can be that we go in there with one thing and then it turns out to be something much more serious, or vice versa. And I do think that withdraw, and I agree, is cleaner than exonerate. In this situation, because there is like a mathematical 51%, but when you think about that, you have to think about the totality of the circumstances. To have the only way for me, based on the severity of the allegation and the multiple witnesses, and also I found those witnesses to be credible, right, and that they believe that that's what they heard, that they said, there would need to be a recording of some sort that really disproved that that's what was said. And absent that, I don't think in good conscience, or in that I could professionally support exonerating an allegation, because to me that says that it didn't happen, or that it did happen and that it's within policy. And that just was not what was presented to us in this situation, unfortunately. Like, we all wanted to have some sort of resolution here, and I think we dug deep in every possible way to figure out exactly what was said, but where we landed is not necessarily clarity on exactly what was said, but clarity on that something inappropriate was said. Also, from a policy perspective, I do think that I like the impact, because what we're also doing here with these complaints is creating like a level of precedent, even though it's not a legal precedent. It's a precedent in terms of how we deal with these investigations. And I like the idea of personal contact and something that's said under your breath, but in the presence of the public, particularly in a courtroom where other people can hear, being something that falls within a personal contact purview. Because I think the traditional kind of application of personal context is that, like, it's implied that you're saying it to someone. And while this comment was maybe about someone, it wasn't directed to him where he could have heard it. Like, the person who I think it was directed to didn't hear the statement at all, but it was still heard by people in the public. And I think that is a positive, a net positive, in terms of expanding
what we mean in terms of holding officers to a level of professionalism, similar to when we had the case where we reviewed body-worn camera footage where an officer said something under his breath that wasn't heard by the complainant in real time, but heard afterwards because they listened to it on body-worn camera footage, and we still held that officer accountable. So I think about those things too in terms of that, like the broader implications of how the policy is applied. And so I just wanted to highlight that too as a positive in terms of how we came out in this situation, understanding and naming the, like, I don't know that anybody necessarily walked away from this case feeling 100% satisfied in the sense of like, will never know exactly what was said. But we are clear that something, as I said earlier, that was unprofessional was said. And so I think sustaining that versus exonerating something where we have, for the same exact reason that we don't know exactly what was said, is more appropriate.
Thank you, Mummy. Just to take a step back sort of towards our like ability to discuss and get to a vote. The evidence available, right? Like that they all allege, and believed what they thought they heard is evidence, but the totality of circumstances being that, he did have an expressed, frustration going into the situation that was totally unrelated to the people that comment would have been directed at. And that, his acknowledgement of having, like, it didn't seem like he was trying to avoid acknowledging that he used profanity. He confirmed that. And that, so it just, in interpreting, right, the interview, the circumstances and the allegations, to Mummy's point, it's not to disrepute their account or what they thought they heard or what that, felt like. But then looking in the context of, what was his sort of mindset? What would his purpose have been for doing so in a courtroom? Not really having a recollection or maybe necessarily an awareness of who specifically those people were related to the case. So to me, that's sort of where, when we talk about a preponderance of evidence, it is multiple different types of input that were available to us and the kind of information that wasn't available to us, like, a recording that would have told us exactly what he said. And so we can speculate about what he might have said that led to that interpretation, but we don't need to, right? That, like, from the available information that we do have, it seemed more likely than not that he did not direct a racially charged profane comment at, the people who heard it.
Right, that's what I think as well.
Okay.
I also think in terms of, because I thought about, well, did he lie to OPR? And I couldn't think of a reason why he would lie about that, because the difference between, assuming that I don't think he made the racial slur, which I don't, then the question is, did he lie between saying something like that motherfucker or you got to be fucking kidding me? Why would he lie about that? I mean, I just think that they're both relatively equal, and that he just couldn't exactly recall something that he said at the time. So that's how I came out on that. So maybe why don't we start with a vote on personal contacts? See where that leads
So
us.
you both are recommending a sustained personal contacts violation.
Yes.
Is there, or do folks have questions or other clarifications? Charles, I don't want to miss you this year online. Okay.
I mean, but if, aside what she sustained also on personal contacts.
She
Yeah,
did, yeah.
she agreed with withdrawn and sustained.
That's correct.
So are we just gonna vote then on personal contacts then? This one?
We don't need to vote on something that I think was withdrawn. We could, vote on some recommendation associated with it if we had one. But I think we only need to vote on personal contacts, and we don't need to vote until we're clear that everyone understands the recommendation.
I would disagree. Sorry, that I think if there is a sense that the conduct unbecoming was the more fitting allegation, I think if the recommendation from the leads is to agree with to withdraw that allegation, you vote on that, whether it's separate or together. So like the vote could be, we are voting that we agree with the COB investigation leads recommendations in totality, which is to withdraw the conduct unbecoming and sustain personal contacts. But if we think that there is the possibility that others may be wanting to vote in favor of a different outcome for those allegations, that I think is just worth noting for clarity purposes.
Well,
And so voting for them either separately or together, but naming the two allegations.
not to be procedurally narrow, but OPR and IPA conduct the investigation and we're reviewing it and deciding whether or not we endorse the recommendation. So yeah, I guess then we can vote on each separately, that whether or
I
not.
think we could if we wanted to. Yeah, so I mean, I
Okay.
think we could vote on something that was withdrawn, but why don't we start with a vote on personal contacts and I wasn't 100% clear in terms of the withdrawal, but I
Yeah.
think the discussion we had, at least for me, was very helpful. So just to state where I am, I'm once we have this, I will vote in favor of personal contacts and withdrawing the conduct unbecoming. I like Mummy's point that where it's the same exact conduct, having two overlapping policy violations is not really appropriate. So, but I think once, depending on the vote we get for personal contacts, I think if there's a vote not in favor of it, then we should have another vote, see what happens.
All right, wait, just.
So let's have a vote. So I'll move that we vote on whether there is a violation of the personal contacts policy and
To recommend adopting the finding that the policy violation was sustained.
right. And should we add in the withdrawal as part of that? I guess we
No.
can.
We'll do that separately.
Okay, all right.
So the thing is, if you sustain personal contacts, why are you, there's no reason to even discuss conduct unbecoming unless you want to talk about whether they should withdraw it or just set exonerate.
Well, I guess that's, yeah, I mean,
Well, putting all the.
I think you all have discussed that.
My
We're just
preference
putting
would
it
be
to a
to not
vote,
sustain it.
right?
So, I mean, that's what I would be saying.
To not sustain which?
Conduct unbecoming and then sustain personal conduct. That'd be my view. Because taking Mommy's view and hearing from Captain Kim and Deputy Chief Chamberlain, it's like, all that makes sense. But the way that lesser included crime merger doctrine works is one way, which is to say that I cannot, and I agree with this, which all of you made, I cannot, I think for the same conduct, say yes to conduct unbecoming and then yes again, personal contacts. I agree that would be unfair, but it is totally fine legally and administrative as well as criminal law to actually say no to the higher one and yes to the lower one.
But shouldn't you start with the higher one? I sort of feel like if this was a murder case, you'd start with, was it murder? You would
Right.
start with, was it,
Right, but we didn't have enough for that.
But what he's saying is, he's saying you wouldn't exonerate on murder, but you could not sustain and then go down to a lesser included.
So that would be my preference. If I'm alone on that, obviously that'll just be a failed vote. So I'm just trying to make it clear.
To me, it's sort of like, want to talk about conduct unbecoming, start there and determine whether or not,
Yeah, just start there.
that's the place to
Yeah.
start. And then go.
Okay, so
Okay,
this is
so-
more procedural.
I'll hear a
Yeah.
motion to adopt the recommendation that the conduct unbecoming allegation should be withdrawn. Do I hear a motion?
I'll go with that. I'll sustain that. Or whatever. Yes, let's vote that.
I so move.
Whatever you said. I agree with that.
So if we don't do that, then we would.
vote on it.
Not sustain.
If the motion to withdraw the conduct unbecoming fails, then we'll have a vote on whether there was a violation of conduct unbecoming.
Okay.
Yes,
Well,
correct.
God, my
Okay.
God, I'm old.
Do we endorse the recommendation
That's it.
that the conduct unbecoming allegation should be withdrawn?
Yes.
I'll
Make
second.
that motion.
Okay, Lisa moves, Dave seconds. All in favor of adopting the recommendation to withdraw conduct unbecoming? Aye.
Aye.
Aye. All opposed, any opposed? Selena and Joshua, abstentions? Charles, what was your vote?
The way that it looks like these votes are going to be phrased, it looks like I can vote for both of them actually, because I believe there's a solid rationale between both of them, because the second one can be housed as a recommendation within our comments. So to the extent that voting yes for this one would negate my ability to also vote yes for the other one, I'm voting yes for withdrawn, and I'll also vote in favor of the fact that it could have equally been not sustained.
Okay,
So Okay, that makes it tough. So there's 4 votes to withdraw it. All right, so let's just go ahead and hold a vote on, but then we'll have to figure out what our actual recommendations. I don't know that we can, Charles, on that point. I'm not sure that
Well,
we
it's not,
can.
this isn't our recommendation, this is our finding, right? So that
But
we,
I don't think we can find both that it's withdrawn and that it's not sustained.
no, we can't, but there won't be a quorum for either of those votes.
You
Yeah.
can certainly include in your report, to the, like,
Yeah.
similar to a dissenting opinion, there were members who voted that it was, that a not sustained, or it was raised, that a not sustained, allegation or finding could have been more appropriate, and state the reasons why.
We don't have to
That's,
vote
I
until
think
we,
that's perfectly fine to include in your report.
Okay,
like, we're just recording what everybody voted on, and we only adopt a finding if there's a quorum and we vote yes.
okay,
So
so,
as it stands,
correct,
we have 4, 5, and 2,
right, 5 and 2
Charles,
and for withdrawn. And so now we'll have a vote on
on
whether.
whether it should be not sustained.
Do you want to make that motion?
No,
So does he-
no, you would, because the motion carried on the withdrawn, then that's it. Now
Yes.
you would vote on the personal contacts. If it didn't carry, then you would need to go through each
That's right, yeah.
finding and vote on which one was the quorum.
So just for
Does
purposes
that make sense?
after the fact.
Or Ethan.
So the two who, everyone voted yes except for Selena and Joshua.
Correct.
Charles, your vote is yes for
For both.
Well, no, just for one.
For purposes of
withdrawn.
meeting minutes.
I do believe though that there is a space for there to be a statement
Yeah.
regarding how non-sustained could be applicable here.
Yeah.
Because my fear is that someone down the road could misinterpret this conversation to mean that that in similar circumstances, we could get to the point where we wouldn't actually explore 41402 and 412 concurrently, that we would preemptively go towards 412 possibly, and I wouldn't want that to happen either.
Yeah,
I
so what
believe
we're saying
there's
is
space for 414.
We can-
Legitimate 414.
we can include that in the report.
Right.
Because they did consider it.
No. But whether or not but he's saying he doesn't want there to be confusion about what we're endorsing by
Okay.
saying
Right.
we
So-
agree that it should be withdrawn. That does not mean that we agree that there can never be, that we had a quorum consensus on whether there can be a not sustained and a sustained for the same conduct.
Correct.
Right? So Charles, that can be clarified. That doesn't need a vote. That just needs,
And I think Ethan, for the minutes, you could,
Yeah.
if it's okay with folks that voted that way, that you could identify that the votes that were opposed to withdrawal would have voted non-sustained. I don't know if you want to go that far or not.
or that there was a discussion about why.
There was a
like-
discussion about.
So I also just need clarity on, Charles, what's your, for the record, the official record, what's your vote? Is it, because I understand you wanted to make a statement on that, but I need to understand if you are voting for it to remain, like, you're voting that it's withdrawn while making that statement. Is that correct?
That is correct.
Okay, just wanted to make sure I had that for the official record. So I'm good now.
Okay. All right. You learned something in every meeting. And the procedural stuff is actually really valuable. And I think we're still sort of inching our way through this. So I appreciate that. Okay, any other, okay.
So vote 2 is, do members of the COB move to adopt the recommendation that the policy, that the personal contacts violation allegation is sustained?
Right.
Do I hear a motion?
I'll so move.
Do I have a second? Selena seconds. All in favor, aye.
Aye.
Any opposed? Any abstentions? All right, that's unanimous. So 7-0-0. Okay, great. So before we close out the investigation discussion, setting the broader stage, right? That the circumstances that led to everyone being in the courtroom had to do with the subject of that hearing. Do you want to elaborate on that?
Sure. Yeah, so the COB would like to raise an issue that wasn't directly investigated and was ancillary to the complaint and the allegations in the complaint. And that has to do, as Julie said, with what the substance of the Officer One's testimony was, about which he was cross-examined and about which he was frustrated. And that relates to his misidentification of the defendant in that case. So starting at the beginning, the case was triggered when police were notified that an individual had broken the front windows of the convenience store at the Shelton Apartments. They arrived on the scene after the perpetrator had left, and they got a surveillance camera from either the store or the Shelton that looked out over the scene and showed an individual, a black male, who had taken up some chairs and slammed them against the store window. And they circulated that video to other officers at ACPD asking for help in identifying that person. And so the video came to Officer One, who, as we said before, had been on the police force a long time, and had done certain surveillance work at various times. And he looked at the video and initially identified the person who broke the window as the defendant. And just to describe the video briefly, video shows a number of people, but it primarily shows the individual who broke the window in discussion with another person who was apparently restraining him from some contact with a young woman. The young woman gets in the car and drives off. And there's a little bit of tussling between the person who ultimately broke the window and this other person. Eventually, after maybe 30 or 40 seconds, the individual walks towards the window, and you can see clearly he picks up these chairs and breaks the window. He then walks out of the frame of the video, and the other person, who had, I think, fairly characterizing it, had been trying to restrain him earlier, also walks past the camera, and you can see that person as well. So initially, Officer One said the person who broke the window was the defendant. As a result of his identification, an arrest warrant was generated for the defendant. And a couple of months went by, the defendant was arrested. At the point that he was arrested, he had, I believe he had weapon and drugs on him. And he was like two and a half months later arrested. The case against him was proceeding. And as Officer One prepared for court, he re-reviewed the video. And when he re-reviewed the video, he found that he had misidentified the defendant. So
As the person
who broke the window. And what he found was, oh, it's not the person who broke the window. The person I thought broke the window is the other guy, who was in the video, who was actually wearing orange, and the person who broke the window was wearing black. It's kind of a weird thing, but he immediately wrote a memo to his superiors saying, hey, I made a mistake on this. The other thing that I think is important is to note that this was so he reviewed the video in October, and the defendant was arrested in December. He re-reviewed the video in April of the next year. Going back to October, if you go back 6 months prior to that, in something like February, the unit that Officer One was from, which was a relatively small unit, issued a bulletin to the rest of ACPD identifying the defendant as a dangerous individual, and just sort of a heads up notice. It was a bulletin saying, if you have contact with this person, or you be aware that he has been involved or is thought to have been involved in dangerous circumstances and has armed robbery and had brandished a weapon at one point. So it's sort of a heads up. So given that, one of the concerns that we had was, okay, well, it's really good that the officer realized that he made a mistake, but the process by which he identified the person wasn't really reviewed by anybody else and led to an arrest warrant, which is a significant legal act. And this has nothing to do with whether the defendant is a good or a bad person or did not do X, Y, Z. It just has to do with the fact that the police generated arrest warrants based on one officer's identification, and that led to the person's arrest. Immediately, well, not immediately, a couple months thereafter, or no, it was less than that. It was some period of weeks after he was arrested. The officer realized he made a mistake. So what we want to do, and what ACPD wants to do, is to make sure that you can be as certain as possible. I mean, humans are going to make mistakes. Civilians make misidentifications. They do make mistakes all the time. Officers are humans. They're going to make mistakes, and nobody's saying that you can't ever make a mistake. But I think one of the things that we'd like to recommend is, can ACPD develop a procedure whereby someone does some sort of verification or identification check as best as possible of a situation where an ACPD employee makes an identification that leads to an arrest warrant. So,
And just to clarify, when the officer watched the recording the first time, they did not watch the video all the way through. And
Right.
so they only saw in the frame, or like up to that, they made the identification based on the first person sort of approaching the camera, where
Right.
the rest of the video then shows the second person, which was when he rewatched it later, it was watching the whole video that he saw the second person and said, I made a mistake. I thought it was this person, but it was actually this person. And again, to your point, only to say humans can make mistakes, having somebody else to corroborate that might have led to somebody
A better
else having
outcome,
watched the
perhaps.
whole video.
right, and to link the point together with regard to the bulletin that went out, I mean, it's possible that the officer was sort of subject to a confirmation bias in the sense that his unit put out a bulletin about this person. He knew that person was a bad guy, just to use that colloquial expression, or had done criminal acts about which police need to be aware, and that he's thinking about that when he sees the video. And I mean, I will confess that I have difficulty with his testimony at the hearing, but I'm going to put that to the side for now, because I found it hard to really track his explanation of why he made the mistake. But I'm going to put that to the side because there's nothing I can do with that. But the bottom line is, I want to focus on the procedure. And I mean, we've had brief line discussion, and I know that ACPD obviously considers that, has the same goal as we do, right? As the same goal that every person in the public has, which is, let's try to make the best possible identification. And so that's where we are. I mean, is there anything else that anybody wants to add to that?
To avoid again, to
To
your
avoid
point,
the circumstance, right?
avoid misidentifying anyone that
Anyone.
could lead to misattribution.
Right.
Yeah.
Right. Any other thoughts, I mean, about?
Just first, any questions on the circumstances sort of leading to the recommendation? With some clarity, Mummy or Albert, anything you want to emphasize?
The only thing that I want to emphasize is what I talked, in our, pre-discussions in preparation for this hearing, which is and thank you, Dave, for bringing this up, is that we share the same interest, which is no person should ever be arrested if they actually did not commit a crime. And so I don't know what that looks like when we talk about using video and maybe a pamphlet or a bulletin to identify an individual. What I would like to see happen sort of in the sometime very near future is to get some individuals, like almost like a work group together and say, hey, you guys are some detectives, you guys are some proactive police officers. What does this look like? What does this extra check look like? Is it something that, maybe someone outside the unit looks at? Maybe it's something that a supervisor observes or whatever, but having an extra set of eyes look at like whatever video or photo before you go down to the magistrate's office and swear out a warrant. And in this particular case, it wasn't a significant warrant, but I mean, what if it was a big time, right? Like a serious charge against an individual?
Well,
I just don't
his
want-
warrant did result in his arrest.
He did have
It-
friends. though.
Right.
Yeah.
When he was arrested, it became
Yeah.
a bigger deal.
It can't, well, yes, but that's because he made some personal choices. But
Right.
what I'm saying is, I don't want someone to be arrested, for something that they didn't do. So we share that same interest. I'm not gonna just wave my wand and say, this is what it needs to look like.
Yeah,
I
no,
think
absolutely.
that's for the internal stakeholders to come and figure out. It doesn't need to be overly complicated. It just needs to be a thing.
Right.
And
No.
so because I do not want this to happen.
No, I appreciate that. I mean, and just one other fact, the officer at the scene who arrived after everybody left, and I think was the one who circulated or helped circulate the video in the first place, which is a good police move. When the officer one made the misidentification. Officer one, I think, was the one who actually went and got the warrant, but that person didn't do his own personal check. And again, whether he's the right one to do it or whether it should be a supervisor or how it's done, that we're not making any demands with that regard, but I certainly appreciate your.
Figure it out. Let's figure it out. There's a better way of just having someone verify before we swear out the warrant, which I think is just common sense.
Tommy?
I appreciate that.
So for me, the irony here is that while the alleged racial slur was, on its face, the more serious of the two allegations, and this one kind of took a back seat, which I don't agree with, it taking a back seat in the sense of like it not being addressed. But I understand like on face value why the racial slur, became the forefront. But in this particular, I have like more issues with this one because I walked away from this with more questions than I had answers. And I want to be clear in that the complaint made two allegations. One is that the statement was made, and two, that Officer One gave false testimony as to the circumstances surrounding this misidentification. While a judge ruled that the identification didn't need to be suppressed, I think that does not absolve us of the need to dig deeper. First of all, to address the complaint that was made by the complainant, but to also dig deeper into like what took place here. Based on what I heard in the interview and like how things played out and what I read in the transcripts, I don't draw the conclusion necessarily that it was an intentional, or really I don't have any reason to think that it was an intentional misidentification, but the analysis can't stop there because I still want to know how this happened, why it happened, and I think that it is our responsibility to do that. It is, and while like the answer to that may not be that an allegation needed to be formed or that discipline needed to be imposed, but at the very least, we could identify what the point of failures were and come up with a more informed protocol and procedure. And also understanding how this happened, I think is a bigger piece, but we can't truly understand how things happen if we don't actually investigate them and ask the right questions. When I look at the footage, the store footage, and even listening to how the defendant in this instance was characterized, like I want to underscore that the defendant on the video, not only is he wearing a completely different color, but he's trying to break up a fight. Yet and still, he's being characterized even way after the fact in the administrative interview phase as someone who was engaged in a physical altercation. The fact of the matter is he was not. He was trying to restrain the other individual, the person who ended up breaking the windows, from placing his hands on the woman he was involved in some sort of dispute with. So he wasn't acting violently in any way. There was additionally maybe a bulletin. I tried to get a copy of the bulletin so I could see that may have suggested that it was the defendant, which could have also, led to the officer's conclusions. It could be the results from what I can, kind of gather here, because one can only speculate. What I do know is the explanation given is concerning because it doesn't quite make sense to me, especially when you look at the footage. But the two issues is that one, like, understanding the severity of the consequences, it's not lost on me that there is an opportunity here where we need to talk about humanizing the impact of this misidentification, right? It would have taken you 2 minutes and 39 seconds to watch the entire footage, understanding the consequences of that. But if you perhaps go into the viewing of the footage with an idea of who this person is suspected to be and what their history is in the community or what have you, I think that not only similar to like if you were showing someone a lineup is suggestive, but it also, contributes to what I think is dehumanizing the impact of identifying this person, where you use basically a picture, looked at the video, didn't even look at the whole video, and draw that conclusion. And then even after the fact, you're looking at the footage and saying this person was involved in an altercation and was acting violently. And what's in front of us is not. And that when I was trying to unpack like why when I was listening to the interview and reading the transcript and looking at the footage, why I was not um satisfied, or why I felt like that they just didn't align, like it just didn't make sense to me. And that's because I'm looking at footage that shows this person as doing something else and how he's being portrayed. And that, I think, when you think about just I'm just trying to unpack, like mentally and psychologically, like how you're viewing something. I think that there is some, even if it's out of an abundance of caution, an opportunity there to talk about potential confirmation bias. And that should inform the protocols that we are implementing in terms of identifying people, because there isn't an existing protocol, and that in and of itself is a problem. But like, let's start with watch the whole video. Let's start with have someone else cross-check you. Let's also have a overarching kind of training, or just, emphasis on checking any sort of confirmation bias, or anything that, some information that you may have that's suggestive, which is why in good practice, what I've seen in other departments, and granted, you're going to have different levels of cross checks for based on the severity, right? Like I would absolutely assume that there's a completely different level of cross-checking for something as serious as a murder versus vandalizing a store window. But having someone that's not involved is a better way to ensure that there isn't any element of background information or suggestive information that you may be taking into your assessment of looking at the circumstances completely objectively, and just making sure, even if it's just a cross check. Not saying that someone who's involved in an investigation shouldn't be the person making the ID, just having that cross check in place. But I think it was at the very least very negligent to not watch the whole video and make sure. When I looked at the video, like, the defendant was only not directly in view of the camera for like 6 seconds. But because of the fact that there were multiple people out there, because of the fact that you have 2 people in this video, 2 people of color who, are wearing different things, but unless you can really focus in on their characteristics, may look similarly. You just want to make sure, for a fact that there's at least 2 black male presence. I would think that you would, if you're valuing the impact of your identification, you're going to want to at least make sure that it's not one or the other. But to watch the video and to cut it off at whatever time it was cut off with a definitive answer that it was a positive identification that it was this person is, like, for me, it's not a question of whether it was intentional or not. I have no reason, again, to think that this was intentional, but that does not absolve us of the opportunity to investigate how and why this happened. And I think the fact that there was no training recommendation or protocol recommendation, as a part of this like investigation or report, I think is a missed opportunity, which is why I wanted to emphasize that in my report. There's absolutely an informed way to go about making sure that this does not happen again. And that's my rant.
So a couple of things I'll need to interject. So first of all, thank you, Mummy. But, I think you hit the nail on the head, which is view one of this, because I listened to the audio of the court hearing right before I came into this hearing, and it was contentious. Like defense counsel and officer one, there is a little contention there going back and forth. And it stated multiple times, to Mummy's point, that the video on the first view was not watched in its entirety. And that officer believed it was the defendant when he saw it. Now, was it a mistake? Was it negligence? Yeah, I can count off all those things. But here we are now, and we've already discussed, or I've discussed as an agency, let's find a path forward. So I'm recognizing the fact that this can't happen again. We're certainly recognizing as an agency, we need to find a clear path forward about what extra checks we're going to put into place so this does not happen again. That I want to just make sure that's abundantly clear. The other thing I want to come across is that, I think there was some, I just want to be careful with the language that we're using about officer one. I believe that that individual, Officer 1, just stopped watching the video, should have watched the entire thing, 100%. Does that mean that that was just an error on their part? I don't think, to Mummy's point, it wasn't intentional. They weren't out to get this individual. They should have just done a more thorough job. Maybe watched it a couple of times, before you're going to stamp this. So, I just want to point that out. I agree with it. I agree with a lot that was being said, but I also don't want to drag this person through the mud and say, hey, you blah, 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 blah. You made a mistake.
Sure.
You got to figure this out.
So I wanted to just clarify something I heard from Mummy, because I do hear a lot of functional overlap. I mean, what I heard you say is that what you'd like to happen soon is to convene a working group of folks who regularly do this to say, what is the best protocol? Because it could be easy to say, if a second person had to sign off on this, if they had to go show the video to someone else, the likelihood that they both would have stopped without finishing a short video, is lower. And that also that avoids something so prescriptive, like you have to watch, a policy that says you have to review all evidence is like, this was a mistake. We don't need a policy that says, don't make a mistake. But is a secondary sign off sufficient? Does there need to be some specification that second person not be, something or other? So what I'm hearing you say, Albert, is what you'd like to do is get input from those folks to figure out what's the most appropriate protocol. Like, you want to adopt a protocol, you'd like kind of primary stakeholder or one of two primary stakeholder groups input on what would be the right way to do it. So you don't write a policy that's either too narrow or too broad, but that serves the purpose, right?
Yeah, and thank you. And I want to say, like, in the court testimony, what happened. The officer 1 basically says, I stopped watching it on the first iteration. This is what happened. So, I know what happened.
Right. For the purposes of the policy takeaways, Mummy, is there something else in what you're saying about, what happened and how we got here that needs to be addressed? Is there anything else from your perspective that either the COB recommendation could include, or just point of clarity? You might be on mute, or maybe I asked the wrong question.
No, sorry, I was trying to find my mute button. I think it's the ID piece, but it's also the other piece that I wanted to draw out was a practice administratively that we don't dispose of allegations in a complaint because a legal finding was made, because our purview is entirely different than what a criminal court or a civil court or whatever purview may be. And I think, again, that the goal isn't really, what the outcome should be from a disciplinary standpoint, but what we can learn from investigating those and how that can inform better protocols and procedures.
Okay. The other thing I would just like to add, and I think this is sort of an ongoing area of consensus we've talked about, but that, we've talked a lot about implicit bias in previous cases, that you can't make a policy that punishes implicit bias. Humans have that proclivity, including probably confirmation bias, but that there are probably things separate from this protocol, which is not narrowly or targeted at confirmation bias specifically, but misidentification of people, that separately confirmation bias is an area where that's a kind of human tendency. You get some information and you see it elsewhere. One of the ride-alongs, I remember they were saying, when there's a readout and it says we're looking for somebody in a black sweatshirt or whatever, all of a sudden everyone you see is wearing black sweatshirts. That's normal. And so I just want to echo that I think there's an ongoing recommendation we've made about finding a way to explore, whether it's training, whether they're cultural facets, whatever it is, to sort of emphasize that kind of proactive self-screening for bias. And I'm not a professional. I make all kinds of mistakes. I have implicit bias. So to Captain Kim, your point, this is not about honing in on one person or one mistake, just that as part of this, because I do think that seemed like a possible influence on the misidentification, to just reiterate that we have sort of open open conversations about what's the right way for the COB to either participate, suggest, recommend, co-create, things that address implicit bias, because we don't have a good clean answer for it. We can't make a recommendation to ACPD that you guys should be doing this, that you're not doing because of blank, but it's an area of kind of continued exploration, because it does often weigh in on cases where, whether it's people of color or other sort of groups, that it comes up on a recurring basis, that implicit bias is, often involved in some of the human error that we see, even when it is, kind of unintentional and not malicious. So, Mummy, I made a note of your recommendation about the court findings not precluding our exploration of different facets of an allegation, just because, like you said, I think in your report, it's not for the purpose of, over penalizing or something, but it is for the purpose of figuring out what more can we do to prevent these circumstances. So we have to understand them.
Right. I mean, just to clarify, like the court issue is different than what we're grappling with. I mean, the court issue was if the court had found that the police had made were grossly negligent in reaching the identification, then the evidence could be suppressed. But that's a different legal issue. Right. That doesn't preclude us from saying, putting aside that then the court found that there wasn't gross negligence. Okay. So that doesn't preclude us from saying, yeah, but there might be a better way to have a better process, for the point that Captain Kim already made, which is we're both aligned in the desire to not have misidentifications, period.
Right. Okay. Any other questions or comments from the COB?
On my end, Captain Kim mentioned pulling a group together, but to the extent that, this is an issue of sufficiency of procedure or lack thereof within department, might also suggest that as that group comes together, they just look at best practices in general, and they also look at our brother and sister departments in the area to see how they address recognition for probable cause, Fairfax, Loudoun, Alexandria, that they may also be able to provide us some guidance, that it's not solely, on our heads, but perhaps there's some greater thinking out there, because as the officer one mentioned in his own interview, these type of IDs, doing these type of IDs are asked several times a week. I believe he said 5 to 10 times is just, per week. I'm asked for different ways to give, identification, stuff like that. So that's definitely something that really needs to be looked at, and will be well served by doing it. So I'm so glad that the ACPD is already on it. I'm just hopeful that they also look beyond and see what's already happening out there. So they don't necessarily have to reinvent the wheel.
That's a really good point, Charles. Let me just add, though, that the recommendation relates just to when there's an identification that leads to an arrest warrant, because there's a lot of police work where maybe this is.
You just
Yeah.
need something.
Right. We're talking about a formal process.
And Charles, to your point, that's traditionally what we do when we are trying to figure something out, is we do go to our counterparts around the region and ask them, hey, what do you guys do for X, Y, and Z? We're looking at doing something. So that is a question that I often field, because I have a lot of, my counterparts in the OPR world generally deal with the same types of issues that we do. So that's a very quick return as far as policies and procedures.
Okay.
Perfect.
So I've clocked 3 recommendations. I'm going to read out and see if folks have questions, because if we don't, we can vote on them as a whole. And if we do, we can vote on them individually. The first one is Mummy's point about sort of our recommendation that ACPD not discontinue exploration of an allegation because of a court finding. That the administrative investigation purview goes beyond that. And so it's our recommendation that we, in future cases, fully explore the allegations to the extent that we can.
Yeah, I mean, that one's, I don't know. I'm not sure I understand the the breadth of that recommendation. I mean, I totally agree that a legal finding isn't going to preclude an administrative action, and there's always a little bit of a difference between the administrative action often, and the legal issue, and that we're not bound. I mean, I don't know if we need to make that a formal recommendation. I guess we can.
I think,
I mean,
well, it's a recommendation from Mummy's report. So the question is, do we want to adopt it? Mummy, did I represent that faithfully?
Yes, that's right.
So that's recommendation 1. Recommendation 2 is, as it sounds like ACPD is, I'll just say, Charles, you're not here, but Captain Kim was nodding along emphatically that, that's part and parcel of what it sounds like they're planning to do. So implementing a protocol for confirming or swearing.
So I'll just read what I wrote
Oh,
on
yeah,
that
sorry.
one. Okay, so the COB recommends that when an ACPD employee's identification is used in an affidavit to support an arrest warrant, ACPD develop some form of procedural regularity for such identification procedures and/or some form of identification verification, such as supervisory review and sign off on the identification. It doesn't constrict.
Stipulate what it is.
Right, it's up to them.
Cool. And then recommendation 3 is just that we reiterate our recommendation that especially in cases dealing in, allegations involving racial bias, but also in this instance, some sense of possible implicit bias, that we keep exploring with ACPD's kind of partnership mechanisms for addressing that. Just so to reiterate that that's an ongoing and kind of outstanding.
Do we need to make that a formal recommendation? I mean, I would just, it's easier for me at least to have it written down and to like make it explicit. I mean, I'm in a line with it, but I'd rather not like just throw it out there before like writing it down and circulating it. I mean, I totally agree.
No, that's fine.
But let's do that.
Okay, so let's vote on recommendations 1 and 2.
Okay.
Mummy's, which is the.
In her report.
Yeah, in her report. I actually have that. Yeah. I can read it if I can find it.
I think it's on the second to last page.
Yeah. The OIPA, nope, that's the same thing. So that's here.
Can I
Is
just
this not
state it
similar to
so
what we
can
did?
simplify this?
Is this not similar to what we did at the beginning of this meeting where we took some time to smith the recommendation and then at the
We did vote on it.
next meeting, we then voted on it, if that's would help?
We should decide if we need to actually vote like a procedural matter, whether we need to
Okay.
vote on recommendations.
We'll hold this then and we'll start it at the beginning of the next meeting.
Perfect.
'Cause
I
then
think the reason why we postponed it last time is because we needed additional information on what the
Okay.
existing training looked like, and we wanted to fill in that gap. As a matter of course, I do think it's important to vote on your recommendations. That way it's clear that the group adopted the recommendations. Just my 2 cents, I don't know that we should be limited to what's in writing because the conversations elicited at the meetings, particularly with other COB members, may form recommendations. And so I think like those could be, stated at the meeting and then adopted formally, voted on and then adopted formally in your report.
Yeah.
But I think that's just a more efficient way to do it. But if you want to put them in writing, circulate them, and then vote on them at the next meeting, there's no reason why you can't do that either.
We'll
Right,
just
so
do that
actually,
this time because we've got 3 and they're like not parallel.
we should vote on the
Yeah.
first recommendation we made. I mean, like, we didn't vote on that.
Well, let's do that at the next meeting.
Okay,
And then just,
Go
and
back and like reintroduce it and make sure everybody understands.
although this one was reintroduced, well, I think we can vote on this today. I mean, right?
Okay.
and then just
If
as
you're
a
gonna vote
quick
on
one-
some and not all, I think it's cleaner to just do them all at one time. It's gonna overcomplicate things to vote on some recommendations today and others
That's fine.
another time, I think. So I think it should either be vote them today or vote on them at the next meeting.
Well,
You
although
present
the
all
next
of them in
meeting's
writing, perhaps?
formal vote, remember, like, if we're gonna have the next meeting,
Would be in August.
Yeah, so,
But my point is what you're struggling with is to know what you're voting on because the recommendations on writing, we don't have all 4 in writing to put up on a slide for people to vote on
Right,
right
but
now.
we-
It did circulate.
right, this one is ready to go. Let's vote on
Okay.
this.
Sure.
Okay, so I'll read this again. We originally said we didn't need to vote on it, but I agree with Mommy. I think it at least helps to make sure that we're all on the same page. All right, so
If I could, just a quick point, I believe Mummy's point though was that they all should be voted together though. That's one. And then my other point is as we work through whatever process we arrive at for this, just how that jives with what we were voting on earlier when it came to withdrawn and sustained, and at what point is a recommendation something we vote on, or what point is it a dicta that goes into some sort of like, dissenting or side opinion or something like that. So just some additional clarity on that once we work ourselves through this vote on these 4 recommendations would be helpful. Thank you.
So my thinking is, I think it makes sense to articulate as clearly as we can whatever the recommendation is, and I guess they don't all have to be voted on. Like some of them can be the sense of the sense of the COB and in a report.
Well, really quick,
But
Charles,
I don't
when
think they all
you're
have to be
talking
voted
about
on
voting
together.
on with the withdrawal issue, that wasn't a recommendation, that was a finding, right? We were finding that that a violation occurred.
Right.
That's correct. But then when it came to those wanting to make a recommendation as to whether you could have a situation where you could have both concurrently, a situation like 414 and 402, and have one not stained or not, then we decided not to take a recommendation vote on that, but instead posit that as something that could just be summarized as part of the conversation that we had. So
Sorry. We're using the word recommendation in 2 different ways. When the COB leads recommend to the rest of the COB what their recommended finding is, and then we vote on whether we want to adopt that recommendation. Now, separately, we vote on whether or not we want to adopt our own recommendation to ACPD as officially as part of the report. And what Mummy is saying is we don't always co-author, as all 7 of us, every word of a report. So if we're going to make a recommendation, it's helpful for us to, if we're going to represent that in writing in a public report, that the language be like well understood, everybody is on board, and the vote reflects that we did or didn't do that. And then to your point, Charles, if we have a vote where there's not a consensus, there is provision for us to include in the report the distinctions that led folks to have a difference of opinion. So now the question is, we have several different recommendations, some of which are in writing, some are not.
So I still would suggest that we vote on this one. I don't know why all 4 of them have to be together. They're completely unrelated. This recommendation about.
They'll just all go in the same case report.
Well, this one relates to the last case.
Okay, I'm sorry.
Yeah.
You have that on the slide. Yeah, I'm fine with voting on that one.
Okay, good, because it doesn't have anything to do with these other.
Can you
cases.
pull that slide back
Yep.
up? Sorry. I was.
No, I,
Did y'all not vote on that originally? You're talking about the
No, we
recommendation
didn't. We
related to the
didn't.
first case?
we just.
Okay,
we just
okay.
didn't. So, yeah,
That's the piece that I wasn't understanding, Dave, sorry. So you all are voting on the recommendation from the last case pertaining to the First Amendment issue.
right.
It must be after 8 p.m.
okay.
Yeah, I don't think we're all
That was not
tracking
clear
that.
to me.
Yeah. It wasn't clear to me either. But okay, now I follow. That
Yep.
makes sense.
Okay.
Let's vote on that. And then I also have a separate thought in that, like, I think generally speaking, it is likely that sometimes, the recommendations formed by the COB leads will be, the all of the recommendations that the COB wants to adopt, but maybe we create a space where if there are additional recommendations that are coming out as a result of the conversation, maybe we take a 5-minute recess or what have you to put those in writing and then just put them up on the screen if the inclination, which I totally understand, is for people to visually see what the recommendation is. It doesn't have to be in the exact precise wording, but just, denoting what the recommendation is. And then people take a vote at that point, having, seen what the additional recommendations are. Because I know that, when we're talking about these things, the conversations can go a lot of different ways and we want to just, understand where we landed. So that's just a suggestion in terms of how we could possibly address that, whether that's today or in future circumstances. It's dawned on me that we could always just add those in. But I want to make sure that it's easy and accessible for us to add additional recommendations when the discussion leads us in that way without necessarily having to postpone to another meeting or another vote. Because as they mentioned, which is a great point, we won't be having another formal meeting until August. And that seems like a long time to circle back to this conversation. It won't be as fresh anymore.
Yeah, I totally agree, Mommy. That makes perfect sense.
Okay, he has the mummies up in writing, so we can do that next, but let's just go ahead and vote. We'll just vote on those two. Sorry, three, this one from the previous case. So from last meeting's case on video deletion, the COB recommends that ACPD take steps to ensure that every ACPD officer is reminded of or educated about the public's First Amendment right to record and photograph officers in the public discharge of their duty as outlined in policy 574.02. Do I hear a motion to adopt the recommendation?
So moved, Charles.
Second,
Second.
all in favor? Aye.
Aye.
Any opposed? One, abstentions, 0. Okay. Okay, then we can go down to the COB lead's recommendation about the identification procedures. So we're voting on the second bullet here. The COB recommends that when an ACPD, well, Dave read it, but does anyone move that we adopt the recommendation about positive identification verification procedures? Selena moves. Do I hear a second?
A second.
Dave seconds. All in favor, aye.
Aye.
Unanimous. Okay, great. And then the last one is for Mummy's report. I'm just gonna read it out. Yeah, that's fine. So the context is the presiding judge in the matter ruled that the misidentification did not warrant granting the suppression motion and was not an impeachable evidence. The OIPA does not find that a ruling in a criminal case absolves the need to investigate whether or not the conduct aligns with administrative policies. The legal standards and the burden of proof that a judge may consider in a criminal case are different than those of an administrative investigation. So the recommendation here is that ACPD pursue investigation of allegations, even if a legal finding absolves them.
Could you read it one more time? Is it a recommendation specifically to ACPD or is it?
Yes, that ACPD not stop investigating something that was part of a positive allegation, like an affirmative allegation, because a court finding absolved it.
Okay.
Because they're different standards of review.
Right. And actually, I'll throw out this just from my own personal experience I know that the Department of Justice has an Office of Professional Responsibility that reviews attorney conduct. And that is the process that they use. I mean, they definitely take into account if a judge finds an issue to be, they don't say exonerated, but if a judge is brought an issue having to do with an attorney's misconduct and the judge sort of informally says this, that, or the other, that OPR at DOJ will take it into account, but it won't preclude them from doing their own investigation, which they always do. So I think that's similar to.
And it's not to ignore it. It's like, if that's relevant to the, the assessment, that's relevant, but to pursue the investigation and kind of have those findings accordingly. Does that make sense?
Yeah, if OPR's reason for not investigating was solely based on the court's finding, then I would agree. If there were some other reason that they.
Well, that's the recommendation, that they not.
Based on the court's finding.
Right.
Yeah.
That they not abandon investigation of a part of an allegation because a court ruled something related to it.
Okay. Yeah, no, I mean,
know
it's kind of nuanced, but yeah.
Questions? Okay. Do I hear a motion to adopt the recommendation that ACPD pursue all facets of an investigation, even if a court finding?
As written in Mommy's report.
Yeah, as written in Mommy's report. Do I hear a motion to adopt the recommendation? Lisa moves, second.
Second.
Joshua, all in favor, aye.
Aye.
Unanimously passes. Okay, great. We've got just a few more quick things. Mimi did her report out. My updates as chair are brief.
Sorry, I don't want to belabor this. I know we're taking, well, I have 30 seconds real quick. On this investigation, one we actually discussed today. I wanted to just kind of communicate to, OPR and IPA that like, I rely very heavily, of course, on those documents that you give us your reports out. And I find them, of course, very helpful. It's probably about 90% of what I do. I try to, of course, watch all the videos. I try to look at the underlying evidence, but I really do rely on them. That is not to say that, this is like, fix my shortcomings for not having the time to go through all the other evidentiary stuff other than what's in the report. But I do sometimes have concerns with, again, the way that the reports are written, such that so far as focusing here for OPR, it was written a little bit seemingly like an advocacy document to me, rather than an impartial investigation, even though you guys did a ton of investigating, which I did appreciate. And I mean by that is when we talk about the preponderance of evidence, or we talk about the weighing back and forth, we had recognition of bias for the defendant's family, but not recognition of bias for potential fellow law enforcement officers. We had credibility assessments that were taking strength of, hey, this guy was 5 feet away, so he didn't hear anything. But the subject officer said something. So that guy's testimony means nothing, because he didn't hear anything. So the credibility doesn't go to what was said. It just goes to he didn't hear anything. And I think that it shakes sometimes my confidence when I read things like that because it's a mismatch. And so I really just want to encourage, sure, OPR, there's other things, I'll talk with you later if you're interested, Mummy, in the IPA report, that when I see those kind of inconsistencies, I just want to really be in a good, frame of mind that I can trust whatever's in there to know that this is as impartially stated as is possible. Because while I have no reason to doubt the investigation or the underlying facts is communicated, how you communicate those facts does matter. And to me, I don't want somebody saying, oh, I find this not likely because of something like, well, he didn't say those things because nobody heard him say it. The guy was 5 feet away. Yeah, but he said something. So, so it's not like you have 7 equal pieces of evidence now from 7 different people. You have 6 now because that guy doesn't matter. And then you move down the line. And I need to see that rationale because if I don't see that rationale, that recognition, even that there's bias on both sides, then it makes me think that we're missing something. And I don't want to miss something intentionally, and I don't want to miss something unintentionally. And I just want to be sure that I can look at your guys' reports and think, cool, I got what I need, because again, it's 90% of what I try to make in these decisions. And I want to rely on you guys as subject matter experts just to make those. So I'll stop there, but I did want to say that we've talked about it in other circumstances, but how the reports are written sometimes here, it makes me kind of question the underlying, like, I just want to see the recognition that people are going through the steps. And I think that would be more helpful to me and make hopefully these conversations shorter and more succinct, that I can communicate my concerns and you guys can communicate your rationale and I can just kind of go with it. But I'll stop there. Thank you.
Thank you. Leading into a conversation I think we'll have when we have CNA do their report out, like all of these kinds of reports are very cumbersome to put together. It's a lot of information file from lots of different, not just sources, but types of sources. And I think we have, in like investigation questions, like posed to people, provided perspective on something that can seem like it's leading or something that can seem like it's subjective. So it can be really difficult to write these reports, having gone through all of that stuff, but I think flagging it so that we can just like be aware of what those things look like when they show up to kind of reinforce that like shared sense of, credibility and independence, not to doubt it, but to say like, this is what sometimes this looks like this to me, and it makes it difficult for me to accept as fact what, when I look at it, is there as fact. I think maybe.
No, that's exactly it, right? Because it cuts down the time that I have to actually go back and Watch all the videos.
Yeah.
Yeah.
We don't want to wordsmith every report,
Exactly.
but if we see those things pop up, it's useful for us to acknowledge it just so that we can all kind of keep working towards that shared understanding.
And I would just briefly add that I think the report quality has improved significantly in that over the time that, at least that I've been on the COB.
Only been here for you.
I do think the quality has improved. I think we have to, continue to raise it, but there has been.
And I mean, it's a big report to compile both for OPR and IPA, like I said, to kind of go over all of that information. And I think, we've talked about this with the investigations also, that like the process of, like we have to adopt the perspective of the community, the officers and the, subject, person or complainant. Doing that just does kind of take practice. And so I think having that be part of our dialogue is.
So are you saying the OPR report, or are you saying the OPR and the OIPAS report? Are you saying both or just our reports?
Most of my kind of constructive criticism was
Yes.
focused on the OPR report. I have, I would say, related criticisms for the IPA report. But those criticisms are more about kind of stylistic. I'd say that, again, my main thing that I want to try to take away, I don't want to try to make everyone confused with the OPR report, is the rationale following it down through. It wasn't clear to me that the person doing the report recognized that, hey, if I'm going to recognize bias here, I have to recognize bias here. Otherwise, it undermines how impartially that's been communicated. And I want to be able to read these both reports and know that I'm getting everything that I need to make a decision, or at least be directed to the right places, so that I don't have to wonder, did this person just miss something? Because you can't rely on somebody saying, oh, he didn't say that thing because they didn't hear anything. I'm like, yeah, but the subject officer said he said something.
There's
So
some
you didn't hear
edit-
anything.
There's some editorializing in summarizing the facts that's inconsistent in places.
Right.
It makes it feel subjective.
You can't logically, it's not
Even
a
if-
matter of reasonability, it's a matter of rationality. You cannot logically say this person's strong to say that something didn't happen if the actual subject complaint officer says, I said something. It just means that that person didn't hear anything.
Well, I mean, that's a specific example that like, we're not gonna revise the report.
Right,
but
right.
Generally, when we're writing these things, we're trying to, we're compiling a lot of facts into a fact-based report.
Right.
Whose logic follows, and you're saying, even where the conclusion follows the logic, that you can follow.
That's
when
really
there's-
not your notes, because it's like we all reached the same conclusion. But to your point, it's the editorial. Because that's the part that undermines the impartiality of the report. And that's the part that, for both, and this is to both, that sometimes it feels like an advocacy document. And I really like it to read as an impartial document, because I just care what happened. And, saying like, the fact that somebody didn't hear something, they were close, is a fact that goes towards a credibility assessment. Saying, oh, and that can't be accented enough. I'm like, it actually can be, because he said something. So now it makes it seem like you overstated. And that's what I'm trying to communicate.
As we've sort of,
Can I say something real quick?
go ahead.
I think that I hear what you're saying, Joshua, and I really appreciate the feedback. I think that there is always going to be a level of, I wouldn't necessarily call it advocacy, but like, defending the position that you're taking or the finding, like laying out why you have reached a particular finding. I think that is different than editorializing something. Like, it is never okay to characterize something like on a video or the way that something happened as different than like what is there. But when you also have instances where you are trying to piece together like what you based on the totality of the circumstances think is more likely to have occurred, or probably likely to occurred, or possible to have occurred, or just trying to like piece together like why you are leaning in one way, like in terms of your findings over another. For example, I think that it's likely that something else could have been said here given who I believe the target of the comment was. To me, is the objective is to explain why I'm reaching that conclusion, because I think to just say like, I don't think that was said, or I think it was definitively this and not that, is where you get into impartiality. I also think, to Julie's point too, that like, a lot of what we're doing in these reports is trying to summarize a lot of information. Like there was a lot of information presented in this investigation. And so I try to, summarize the main points and then obviously like give a more detailed explanation in the setting of the meetings. But I think to just expect that the documents are going to just lay out the facts and not some level of, your perspective, like to explain your finding, you are essentially, from my perspective, having to, characterize how you view the facts and how that supports the finding that you're making. And I think that is like what that's the fine line for me versus like if you're mischaracterizing something or characterizing something as something different than what it is. But I think like it's a funny it's like a it's a very fine line to like call it editorializing or advocacy, but you are having to defend your finding by pointing out what facts you relied on and what facts you found to be more convincing or leans you in one way versus other, especially in instances like this where it's kind of a close call. While also trying to make sure that I wasn't undermining like the credibility of the other witnesses, because I think the reality here is that everybody had a different perspective on what happened, and that is true in everybody's mind as well. So not to undermine people's credibility, but just to kind of, in this particular investigation, it's hard to state why you've came out a certain way without undermining the credibility of something else or another piece of information, if that makes sense.
Yeah, and I appreciate that. Your response kind of communicates to me that despite my desire, I was somewhat misunderstood. There's a reason I chose the word like advocacy rather than things like mischaracterization or, to your point, anything like that. Because I don't think that I saw any of that in the OPA or the OIPA or the OPR report. To me, when it just comes down to it, because to your point, like everyone's going to have to explain why they reached the decision they did. And perhaps maybe using that as the basis for understanding my comments. What I am saying is that if I read one of these reports and I cannot understand why you reached the decision you did, because your reasons are seemingly contradictory to the ends, like the premise does not reach the conclusion here, maybe that, to your point, that's just a disagreement about where you guys are going to end up. And that's totally fine. When you see it consistently throughout a document, it feels to me like somebody's advocating. And that's different than just explaining a rationale for your decision. And that is kind of what I'm trying to communicate that is coming across.
I get that.
Yeah. So I just
want to. And I agree with that.
Yeah, I want to clarify that because to your point, like, no, I'm not saying absolutely that you or PR, in my view, was mischaracterizing anything. I'm saying that, yeah, I just want to understand how we get from A to B. And if, to your point, that just doesn't make sense because somebody just made what I would consider to be an error, and maybe they wouldn't consider to be an error in their reasoning, that is totally fine. But when it happens again and again, then it starts raising that question in my mind about impartiality. And that's what I had concerns about.
Yeah. Like to me, when I think about editorializing, it's like, for example, you are characterizing what occurred in let's say body worn camera footage, and you're describing someone's mannerisms, right? Like as aggressive or as something like that. And when you look at it objectively, like that's not what it was. And there are ways to describe exactly what someone did and said objectively without characterizing it as a particular thing. That I think is the fine line that we want to draw in how we are communicating the facts of what took place.
Correct. And yeah, I think I said advocacy, somebody said editorialized and I accepted that. But to your point, I take that for the more common definition. So for both yours and OPR's kind of edification and clarity, I will take back editorializing as a comment on that, because I don't think that I saw, to your point, editorializing the way that most people would understand it, which is coloring the facts.
Yeah, but to the extent that your point here is, I would like for you to show your work a little bit more in explaining how you reached a particular finding. I fully understand that, and I think that's a very fair point.
Yeah, to use an analogy from the one we talked about with the video, right? It's kind of like I feel like if somebody else watched or listened to that or read it back all the way through, they would realize some of these things didn't make sense. And they would have fixed it. And so I think, and to your point, if that was done, then you would probably have me not sitting here questioning whether somebody was advocating or whether somebody was giving me the rationale for how they reached the decision.
Yeah, and then there's also the, possibility that sometimes people just accidentally, have it, put something in like as a fact that was not a fact, or like mischaracterize how many people were there, or how something was said, or the sequence in which, something was said. Like there's always, human error as well.
Oh, yeah.
But
Well,
I
it's like
think
the 30
what you're
seconds.
talking about is
Do
different.
not care 30 seconds who left where, because he left and he came back, and that's all I cared about.
Right.
Okay, I think I've captured the discussion here. I do have a line item for open discussion, so I'm just gonna give chair updates really quick, and then I have a note on public comments, and then we can have any other open discussion. Just to reiterate what Mami reported out at the beginning, that our next meeting, we will do a 5-year COB IPA anniversary engagement. We're still fleshing out what that will look like and where it will be. Tabling at the county fair in August. We'll have the CNA folks come to share their findings of their report with us, and we can have a discussion with them. Mami's continuing to review the officer involved shooting. And then I think my last thing is about public comments. So we mentioned this on a previous meeting, but we couldn't access it. A member of the community submitted a public comment in writing, requesting that the COB place ACPD's use of Flock automated license plate reader ALPR technology on a future agenda. There were multiple issues and references raised, so we will take that up for exploration at a future meeting. But because it was submitted in writing and we couldn't read it out at the last meeting, we just wanted to kind of formally acknowledge that we received that comment and that we do plan to address it. So the topic is Flock and ALPR. We'll compile, information, coordinate with ACPD, and raise that in a future agenda item. But other than that, we moved the IPA report up in the agenda. So we have a member of the public online. We do have a few minutes for public comments, if there's any to be heard. Otherwise, any other input from members of the COB? Questions?
Is there any feedback from from being at the Blues Festival?
Oh, from the event. Yeah, it was actually a good. Umar was there, Mami was there, I was there, Vikram was there. I had a lot of contact with members of the public. I thought it was helpful. Ran into somebody who might be interested in applying for the law enforcement member of the oversight board. Yeah, the non-vote. Yeah. So, but I don't know if he will or won't, but I mean, I thought it was really a good event, and I was happy to be there.
Great. Thank you for going. Thank you for doing that.
Yeah.
I was sad to miss it, partly just because it's a very fun event. But
Yeah, the bands were good.
Ethan, thank you for organizing, putting everything together.
Yeah.
Y'all, thank you for supporting. And if that's everything, we are adjourned.
Can I say one thing?
Oh, yeah,
Sorry.
we're not adjourned.
It's not that important, but it is important. I just want to thank Mami. I know I saw her at some point in the midst of our funeral services for our fallen officer. So I just ask that you guys keep a lot of our people in thoughts. Someone with a lot of tenure, a lot of service, and he's mentored all of us in some shape, form, or fashion. But he's also made us laugh, and so I think I appreciate her appearance there, because that is.
Yeah. Thank you for raising that.
Yeah.
We actually, we'll address it offline, but thank you. And yeah, thank you to Mami for going and showing support on behalf of the COB as well. All right, we will see you in a month. Thanks, folks. Well, this is, this won't be a meeting on this.
Okay.